viewers, welcome to our channel. From this channel, we will get some ideas on different types of laws and definitely have some ideas how does law can help to the people in their daily lives relating to different cases like injury cases, accident cases, etc. So friends, without wasting any time, let's go to our new video and let's see what we can learn from this video. If you like this video, please subscribe our channel and give like to our channel. And don't forget to press the bell notification so that when our new video will releases, you will get the notification first. So let's see what we can learn from this video. So today's discussion, slip and fall law. Slip and fall injury. Slip and fall law refers to the liability rules governing cases in which an individual falls to the ground and suffers harm due to dangerous conditions on someone else's property. A slip and fall injury, also known as a trip and fall, is a premises liability claim, a type of personal injury claim or case based on a person slipping or tripping on the premises of another and as a result suffering injury. It is a tort. A person who is injured by falling may be entitled to monetary compensation for the injury from the owner or person in possession of the premises where the injury occurred. Property owners have two basic defenses to slip and fall claims: lack of negligence, lack of fault. Now, what is lack of negligence? The defendant may argue that they were not negligent in creating the condition that caused a person to trip or slip, or were not negligent in correcting the condition before injury occurred. For example, the owner of a grocery store may claim that the banana that a patron slipped upon had been dropped on the floor only moments ago by another patron, and that in the exercise of due diligence, a typical store owner acting with reasonable care would not have had time to discover the danger and take steps to mitigate the danger. Now, what is lack of fault? The defendant may claim that the injured person was responsible for his or her own injury. For example, the owner may claim that any reasonable patron exercising due diligence for his or her own safety would see a banana on the floor and take those steps necessary to avoid slipping on it. Slip and fall claim denied. Some reasons why a slip and fall lawsuit can be denied include your claim was not supported sufficiently with evidence, you failed to acquire your medical records or didn't have them at all, you failed to inform the owner or property manager of the incident in a timely manner. Is it hard to win a slip and fall case? However, despite their prevalence and despite the fact that slips and falls generally result in serious injuries, slip and fall cases are difficult to win. When these types of accidents occur, it is usually because of carelessness or negligence on the part of the property owner. How do you win a slip and fall settlement? To win a slip and fall claim, you need to establish the property owner's liability for an unsafe condition. By David Goggin, JD, accidents on the other people's property happen and injuries are often the result, but when someone else's carelessness or negligence is a factor, you may wonder about your legal rights. How does a slip and fall case work? In a slip and fall case, the liability usually rests on the owner of the property on which the accident occurred. Depending on the type of property you were injured on, the owner could be private, commercial, or a government entity. Additional resources proving fault in slip and fall accidents. What makes a good slip and fall case? To win a slip and fall personal injury case, you need to prove liability. The defendant had a duty of care and was negligent in performing their duty of care. Negligence. How a slip and fall demand letter should be formed. Demand letter should include statement of facts, describe in detail exactly how you fell on the wet floor. Then liability. Explain why the insured is responsible for your damage. Injuries. Describe your injuries and their impact on life. Damages. A cost list of your damages. Do most slip and fall cases settle out of court? If you slipped and fell while on another person's property, you may have the right to receive compensation for your injuries. Most slip and fall cases settle out of court. What is the average settlement for a slip and fall accident? The national average settlement amount for commercial business premise liability cases is $345,000. For slip and fall cases that occur on private property, the national average settlement is in $105,000. Now, how to handle a slip and fall? There are 5 steps to take after a slip, trip, and fall accident. Seek medical treatment. Your health or the health of a loved one should be your number one priority following a slip, trip, and fall accident. Report the accident, document everything, decline to give statements, call an attorney. What type of tort is slip and fall? A slip and fall is a personal injury kind of tort. It is a civil claim based on negligence. The purpose of slip and fall case is to hold someone accountable for causing a personal injury accident. Specifically, a slip and fall personal injury tort is a premises liability tort. Can I sue if I slip and fall? Absolutely. Whenever someone slips and falls or trips and falls, there is a chance it was because of some hazard or obstacle that should not have been there. If that is the case, the property owner or business owner may be liable for the injury. That means you have the right to sue to cover money for your slip and fall. How many slip and fall cases go to trial? Only 2% of cases go to a jury trial. Is a tort liable for a customer injury? If you experienced an injury in a store and the store or property owner's negligence played a role in your injuries, the store might bear liability for your expenses. You may speak to a lawyer if you suffered an injury inside a store or in its parking lot. How much compensation do you get for slipping on a wet floor? Solicitors now take a percentage from the compensation awarded to cover their remaining costs. This percentage is usually 25%. When a person is pursuing a wet floor compensation claim using a no-win, no-fee agreement, they can rest assured that they are not at any financial risk. What are some examples of negligence? Examples of negligence include a driver who runs a stop sign causing an injury crash, a store owner who fails to put up caution wet floor sign after mopping up a spill, a property owner who fails to replace rotten steps on a wooden porch that collapses and injures visiting guests. What are the three levels of negligence? There are generally three degrees of negligence: slight negligence, gross negligence, and reckless negligence. Slight negligence is found in cases where defendant is required to exercise such a high degree of care that even slight breach of this care will result in liability. How long do you have to report a slip and fall? In most cases, you must file within 6 months. Many stores and businesses are targets of phony slip and fall claims. Their attorneys will search diligently for any signs of your negligence. How long after a fall can you make a claim? The general rule of adults who are considering making a claim for personal injury compensation is that you have 3 years from the date of the accident or incident in which to bring a claim. Should I file a slip and fall claim? If you are injured in a slip and fall accident, you probably won't be need to file a lawsuit to recover money for your injuries. You will likely be making an insurance claim. However, your right to file a lawsuit code is the main motivator for the insurance company to settle your claim for a fair amount of money. So friends, today we are ending our video here. Again, see you with a new video with the basic concepts and knowledge of law injury. Thank you.